welcome, Adi and Leo. We are now at key number 6, government. And the publication that you made was make mediation a prerequisite to civil litigation. And in fact, Adi Gavrila and Leonardo wrote it together with me. But today I'm just interviewing you about what's the background of the article and the ideas that you want to bring about. So let's start with the introductions. Adi, would you like to start to introduce yourself?
Sure, absolutely. Thank you, Manon. That was a great experience to write that piece, and now to talk about that, it's even better. My name is Constantin-Adi Gavrila. Everyone calls me Adi, actually. And I am a professional mediator, full-time professional mediator for the past 18 years or so. I was introduced into this field by way of having to manage a pilot mediation center in Romania back in 2002. And ever since, I have been mediating domestic and international cases. In the past years, I'm working more and more with development banks, independent accountability mechanisms of development banks, supporting conversations between clients of those banks and concerned communities with respect to the environmental and social impacts of bank-developed projects. I am working with Leonardo within the ADR Center dispute resolution and development section. We're implementing projects all over the world, and right now, just to give you an example, we're implementing a project in Azerbaijan trying to introduce mediation and an Italian model adopted to the Azerbaijani culture. Finally, I like to write when I have time about mediation, to teach, and to speak with students and others that would like to learn more about it.
Thank you. Leo.
Hi, Manon. Thank you for the invitation, first of all. I'm Leonardo D'Urso, and I'm a full-time mediator, and I'm a co-founder of ADR Center back in 1998, so about 22 years ago. And I ran ADR Center in Italy with 32 offices now. We have more than 5,000 mediations per year. And we launched the ADR Center Global. There's a network of mediation centers in all over the world. And we have a division of ADR Center for Development where we run projects right now from Azerbaijan, as Adi mentions, to Jamaica, in Turkey, Oman, Jordan, Moldova, and other countries. I'm in the board of directors of the Weinstein International Foundation. It's a no-profit foundation based in San Francisco. And lastly, I teach at Strauss Strauss Institute at Pepperdine University as a joint professor.
So there you have a lot of international experience, both of you. So you can have a good overview of what's going on in many different countries around the world. And I'm curious whether that also was the inspiration for writing key number 6, so make mediation a prerequisite, which is a nice reframe actually maybe for a mandated easy opt-out. So let's put a pink elephant in the room. What was the core message that you wanted to bring about? So what's really the core of the article? What will bring about the golden age of mediation?
I think the core of the article was based on our experience, at least our day-by-day experience, how mediations changed in the last 20 years, 20, 30 years, especially in Europe. All the failures that all our European colleagues, all of us have experienced. And I think a few years ago, we saw a light. And just maybe just by chance on this so-called Italian model, but has been, there is in different ways on that we can talk about the easy opt-out model, where that is working very well here in Italy, then has been adopted in Turkey, now in Azerbaijan, in Greece, and in other countries. And it simple is working and is producing thousands and thousands of mediation on voluntary mediation. But we need to then to talk about what really is mandatory mediation, what really is voluntary mediation.
Okay, and Adi, what was for you the key message that you wanted to bring across in the publication?
Well, I think we're looking at mediation and at its great implementation in the Western world, some of the Western countries that have been successful in implementing it. And then we're looking at other countries with less experience struggling actually to implement it, trying to find the right model. And we see that one of the most important education tools is education through legislation. And that component is absolutely critical for societies and cultures to accept mediation. What we did, we took the successful Italian example and perhaps the not so successful Romanian example and tried to learn from these examples and come up with some lessons learned so that the readers of the keys would look at this and see how important it is for the governments to regulate it and make it part of the system, not mandate it, but make it part of the system, a step in the system, a normal step, and then to make it, to implement it correctly. And this is really important because Romania is actually looking for the past 8 years at difficulties because of not so correct implementation of this model. We believe that this is critical, and we strongly believe that this key could be the master key of all the keys that have been written.
Okay.
And by the way, because there is no other alternatives, proven alternatives, that other model worked, at least, and again, in Europe, in systems different from US and UK.
Okay, so in fact, in the article that you wrote, you were focusing more on how to get a better balance between litigation of cases and mediation of cases. So it's not so much about how to improve mediation per se, or do more or different things, but how to get this balance. So maybe that's important to keep that in mind when we are listening to what we wanted to bring across with this key. What I think would be really interesting to look at, because we look at an Italian model where it works. And actually in Italy, you went to a kind of laboratory trying out all of the different models over the past 15 years or something like that. And Adi, you said, okay, we did implement something similar, but we have some lessons learned, but needs to be differently. So it would be great if both of you could highlight the do's and don'ts actually when you want to implement the advice in this key.
Yes, I mean, in Italy, again, this article is based on the experience, on the statistics, data. It's not our opinions, actually, or thoughts of wishful thinking. We look back on the experience of the last 20 years in a lot of member states in Europe, the European Union, or the Council of Europe, and we just counted the numbers of mediation, and a ridiculous low if you compare with litigation in courts. So most of the model didn't work. Simple didn't work. In Italy, we spent we went through all 5 different models, from full voluntary mediation to full mandatory mediation, and now we have this model that, again, in some dispute types, the litigants have to attend a first meeting with a professional mediators. These first meetings can be like 5 minutes or 1 hour, is up to the parties and to the mediators. Should be held within 30 days, so very, very fast from the request of mediation, and basically for free. It's only 40 euro each to cover the expenses. Then the party can make an informed decision to go to voluntary, go ahead with full mediation, or simple opt-out, say, we are not interested, thanks. Well, so again, and I want to, you know, the message is, should be clear to all our viewers. In Italy, we have voluntary mediation. It's not mandatory. Mandatory is only the first meeting. Then the parties meet, they have to make a decision to go to voluntary decision. So what the high witness with thousands and thousands of managing these first meetings, that a lot of times the parties is the first times they met. They have never had the opportunity to meet in the same room at the same time. One party and their lawyers, they do not want to meet, to go to the other office lawyers, simple as that. And courts, they don't have a room to meet. So only just a meeting, just to be in one room, in one place with, of course, a professional mediators makes a huge, huge difference. And now, more or less, 50% they opt out and 50% they opt in. But what we have learned that is not so simple. There are a lot of details in this law that should be take care. I mean, the quality of the mediations as well, the quality of the mediators, the mediation providers. So everything should work at the same times and in homogeneous.
Okay, so you're saying a two-track system is really, really important. So it's not just having a pre-mediation step, which can be either an actual mediation meeting like is the Italian model, but it can also be just an information meeting or a meeting where you just regulate together how to do the process. So we have a guided process, in fact, in there. But so it can be in different ways. However, that is not the only thing. You also need a second step, which is the infrastructure should be with well-trained mediators and so have a good infrastructure. And I think, Adi, maybe there is some of the learning points from Romania, right?
Yes, absolutely. We in theory, if you think about it, we had the same model. We had this first information meeting. It was more than accessible because it was free of charge according to the law. The parties didn't have to pay anything. And that introduced a different challenge, as someone could imagine, from the supply side, of course. And theoretically, that was in full compliance with Article 5 of the EU Mediation Directive. It was well accessible and easy to be organized because Romania at that point back in 2012 had about 20,000 mediators already trained. But the problem was that the policy was written in a way that was actually creating an obligation for the plaintiff to attend that meeting and for the mediator to invite the defendant, while the, let's say, responding party, not the defendant, the responding party was kind of free to ignore and to decide if they want to attend or not. It was not encouraging the defendant at all to attend. Hence, 90+% of all the meetings were formalities. So basically the policy transformed mediation into a formality, what exactly mediation doesn't want to be a formality. Hence, if you add on top of that, the fact that the policy provided for a strong sanction of the plaintiff, if they would not go through this stage, the judge would have to dismiss their case as inadmissible. It was a matter of time until the Constitutional Court commented about the fact that the sanction is not constitutional, not the obligation, but the sanction. And actually, I was so personally challenged with that whole system that I had to go through a 2-year research, and I did my PhD on mediation and access to justice. So.
Oh. So actually, this piece is one of the core things that you really researched over the past years, and also from personal experiences in there. In the article, you write that even if it's just some information meetings, the advice is let it be done by experienced and well-trained mediators. Why is that? I mean, why can't a mediation advocate or somebody from the court system, why can't they do it?
Well, because the first meeting is very important. It's the first times that the parties themselves, they and sometimes the lawyers, they sit with a mediator. It's not only the fact of the mediators, but also the organization, the mediation providers is very important. In our model, mediation providers are the ones that are managing all the mediation. And there are a lot of work. I mean, when you receive a request for mediation, the providers has to, to notify the counterpart, set a date, an hour. Sometimes the counterpart said, "Okay, I want to attend, but not that day. I have another." So we have to reschedule everything. So this notification should be done, should be registered notification. So there is a lot of work, first of all, and then you have to provide nice space, again, nice conference rooms. We know how the logistics is important. So it cannot be done in courts. And courts are flooded with the cases themselves. They do not have the resources, the staff, the people, the time to be burdened also with the organization of mediation. So it is very important that all this process of case management is done by outside the court without any resources from the court. And the first meetings is done by a professional mediator, because I don't think that at least in our system is not really information. It's more than information. Is up to the parties and to the mediator to spend 1 hour or 5 minutes. And usually now the practice say that we start to mediate a little bit even, and of course we have the passion and I have to be clear, the economic incentives, of course, to push the mediation at the parties to opt in. But this is important. The parties are assisted by their lawyers, so they make very informative decisions. If they don't want to mediate, fine, they will not, they opt out. So I think it is very important that these first meetings is done by a mediator, a professional mediator.
Mm-hmm. You are mentioning lawyers being present. That is a given in the Italian system. I don't know how that was in Romania, Adi. How did lawyers react to the fact that there was a first mediation step? Did they like it? Was there some resistance?
Well, the lawyers in Romania were not consulted as an institution, as a professional group when the policy was discussed and approved. And we know as mediators how important it is to incorporate a good stakeholder engagement process in whatever decision-making process we facilitate. Hence, even a good decision, if not assumed, if not owned by some stakeholders, they may not engage in its implementation just because they don't feel like they own it. In our case in Romania, it was not only that they were not consulted, but the policy, the model that was enacted didn't actually recognize their value, the value that they can have and they can bring to the table and in the mediation room and in the mediation process, advising their clients from the referral stage to the preparation stage, and then to the real, main mediation body stage, and then to the implementation of the agreement. So that was, I guess, a mistake in Romania, and I believe that Italy was very successful to incorporate lawyers in that discussion. Not only that, to design a model that is respectful towards the key role of the lawyers in coming into the mediation process, defending the fundamental rights of their clients in the same time while they're building peace.
Mm-hmm.
And that is really, really important. You can defend somebody's rights while building peace. You don't have to go to war in order to defend somebody. And that is really important. And when the legal profession will understand that opportunity, I think Roscoe Pound said it 100 years ago, they're going to meet a great opportunity.
That is a beautiful way of saying it, Adi. So actually what you are saying is you need the legislation, but together you need also the infrastructure and buy-in of all the stakeholders, so actually mediate this entire process in order to unlock the golden age of mediation, where there is a good balance between litigation and mediation.
Yeah, can I comment on the question that was really good regarding why the mediator is in a great position to facilitate that information session? I think that's one of the keys to the successful model in Italy. I think, first of all, we have to make a difference between referral and let's say facilitating parties' appetite to engage in the process. A lawyer could refer cases, could refer mediation to their clients. A clerk could refer parties, or a judge could refer parties to mediation. But to facilitate a meeting, it's ideal when you have everyone in the room. And that's some setting where having an independent party adds a lot of value. That's why we're saying that having a professional mediator facilitating that meeting about understanding the issues in order to decide whether parties have appetite to engage in a facilitating dialogue process is critical to have a mediator in the room. And lastly, think about it. If we want to go through a surgery, is it good enough to receive advice, to make that decision without actually meeting the doctor? Of course, people can tell us you should go to surgery, you should, and we know, we feel it, but then we go and ask the doctor, can you explain how the process would go? We need to understand exactly what will happen with us, because then we will decide if we'll go with it or not. It's the same with mediation.
Well, thank you very much for this clarification and so beautifully phrased. When we look back at the entire work of the 7 keys, I know each of us read several contributions from other colleagues. Leo, was there something that was an eye-opener for you, or where you said, hey, that is a big takeaway from the entire work? What do you find?
I read all the keys. A lot of contribution. I mean, is a puzzle. It's very important. All the keys have been very important. But I think that maybe I have a bias. Of course, yes. Our key is a master key. Is a master key based on data, based on statistics.
And Adi, what's your main takeaway from the 7 keys?
First of all, let me just say that it was a great pleasure to write this piece with you, Manon, and with Leo. And second of all, I echo Leo's point with respect to the fact that, of course, there is a puzzle, but this key is central, specifically in countries without a huge history in terms of implementing mediation activities. And then, additionally, I think that the other piece that is part of this key, with respect to how this key is applied to the public sector, where the governments will have to take the lead and incorporate this required first step for all the disputes where the public authorities and institutions are part of, could be a great way to start implementing this model. And that key was written by our colleague Christian Kereshi, and I think it's just an echo of the principles that we've been writing about. when the public sector when the governments will start by saying, actually, it's not only that we're enacting mediation, we are actually drinking the poison. We would start applying it for our own cases. Then the private sector and the citizens will see a model, and the power of example is important here and will follow.
So thank you. Is there any final thought that either of you would like to share? Maybe some developments you will see for the future, or how would the perfect mediation world look like?
Well, just 2 days ago here in Italy, the parliament actually passed a law that all disputes related with all contract disputes related with COVID-19. So even everything, so all the subcontracting or renting or other contracts that can be the contract have not been implemented are now under mandatory mediation. So all dispute types that comes from COVID-19 are under mandatory mediation, first meetings. And so this is another development of Italy. Now we have a discussion to extend and enlarge to more dispute types in Italy. And I am kind of an ambassador. I feel me and also Adi, ambassador of this model. And again, I want to stress a couple of things. First, that we should, to shape the future of mediation, we should look back on the last 20, 30 years, look at the data, analyze what worked and what didn't work. So only in this way we can shape a good and bright future for mediation. And another thing is very important, I think, is the difference between jurisdictions. What worked what is working in the US and UK, where the litigation system is completely different from Europe, where going to the court is very expensive. Even if you win the case, you have to pay your own lawyers, where it's much more the predictability of the decision is much higher. Here is very, very different in Italy and most of the European jurisdictions. That's why we need what's a little bit push, a soft push. There's this nice word in English is to nudge. That we don't have actually in Italian, to nudge. And the first meeting is a nudge, is a soft push, and then the parties and lawyers, they decide by themselves what to do.
So the future is nudging mediation. And Adi, any final things you would like to share?
Yes, I'd like to take Leo's point and apply it in our own context. And I'm thinking about key performance indicators when governments are enacting mediation. Our first mediation law was adopted in 2006, and the drafting process took a couple of years, 2004 and 2005. And the Romanian Ministry of Justice identified a couple of issues in the society, such as court backlogs and long delays in scheduling court cases. And then the mediation law was adopted with an intended goal to reduce those backlogs and delays. Now, a couple of ideas. First of all, the government didn't actually identify a number, a percentage, a clear goal with respect to how much those should be reduced under what timeline, so that then we would look back and decide if the policy was successful. So we would know to keep it or to modify it. And another idea is that just 2 days ago, the president of the Senate, Romanian Senate, in a very important online conference, spoke about the fact that the Romanian Supreme Court is scheduling now cases in 2022. So think about it. We are 14 years after the mediation law was published, and we are still scheduling cases 2 years ahead. So was it effective? That's something that should, get us thinking when we enact mediation, what we should do in order to make sure that, it's well implemented.
Let me add a really final thought.
Sure, Leo, you can have the last word.
No. Is another good reason, to adapt to this public policy is about the cost. Think about, about 10-20% of the budget of the courts are covered by the court fees, usually in Europe. 80% is covered by all the tax money for everyone, the taxpayers. So basically the government should say, well, before spending 80% of the taxpayers, please litigants, sit down 5 minutes, half an hour with the mediators, and then decide if you want to go to the court. So in this way, it is a fact that 50% of the cases dropped in Italy in the dispute types where is mandatory this first meeting.
Fantastic. Thank you so much for adding this. I think it's a strong argument to at least consider implementing this key. Thank you so much for this interview. It has been a great joy and pleasure to be working with you again. And see you soon.
Thank you, Manon.
And thank you for organizing the interview. It was great to reflect on the piece we wrote together.
Well, thank you for your beautiful reflections. It's a big pleasure.